are watching Germantown Municipal Television, your source for everything Germantown.
Hello and welcome to Law Talk on Germantown Municipal Television. My name is Vince Perryman and I'm a local attorney with the law offices of J. Vincent Perryman. Each month, Law Talk focuses on a wide range of legal topics and issues. Today's show will discuss how to prepare for litigation. With us now is local attorney Bill Jones. Bill, thanks for being with us again.
Love being here.
I know.
I feel like a returning guest.
Well, I think we've got your name on the back of the chair.
Yeah.
So, this is one of those things that we were talking the other day about, well, what are some topics that we haven't covered in the past that would be really useful to the public? I think preparing for litigation is a great idea that you had.
Well, it's not only, we've covered just about everything I can think of, and instead of being repetitive, as a novel concept, I thought it might be cool to discuss how do you stay out of a lawyer's office, or what do you do to prepare before you go see a lawyer? Because there are things that are helpful. When folks come into us, they generally think that they've done all that they can do. They generally think, I'm at my wit's end, I'm having to go hire a lawyer, so on and so forth. So the question we always get on the phone is, what do I need to bring in? But before we go there, I want to take a step back and let's talk about what can they try and do maybe to not come in and see us?
To stay out of the litigation world.
To stay out of there and not pay you money and not pay me money. So we're actually kind of doing ourselves a disservice here, but it'll work. What I have found is extremely powerful that folks underutilize is the power of a letter. We are in a day and age where we're used to texting, we're used to Facebook messages, we're used to Snapchatting, whatever. And that doesn't convey the sense of seriousness that a letter does. And oftentimes what I tell people is if they're having a problem with a neighbor, they're having something that they want to litigate, have you documented it? Have you written a good old-fashioned letter? I mean, I'm not talking about an email. I'm talking about you take your butt down to the post office, put a stamp on it, and mail it letter. That can serve two purposes. The first is that it can let the other party know how serious you are and that you're willing to take this, escalate it up to another step. The second thing is that's great for you and I. If they can bring that letter in and show us, look, I've attempted to do this. I've attempted to resolve it this way. Because 9 out of 10 times when you and I are in front of a judge, the first question they're going to have for us is, what have you done so far? And it is so much more helpful when we can say, we've taken these steps, we've attempted, we don't want to be in your courtroom. You're a lovely person, Your Honor, we love being here, but we don't want to be here today. We're here because the other side didn't do everything that they could. Look, we did everything that we could. Right. So I think a letter is a great first start. The other thing is communicate, talk. Just try talking to these folks. I've had so many folks that have trouble with their neighbors or so on and so forth, and I say, look, go to Perkins, buy them a muffin, take it over, sit down and talk with them. I mean, pretend that you're at Mayberry and just go sit down and say, what's our problem? Can we work through it?
Right.
Now, sometimes that's not an option, right?
That's right. If you think there's a threat of violence involved, you don't want to do that.
Yeah, if they're standing on their front porch with a shotgun, probably don't try that.
Right.
So if they're taking it to the next step and they need to see us, what are some of the things that they can bring in with them? So let's say that they've exhausted all of their efforts to resolve the case with them outside of court. Now they decide, all right, I need a lawyer. It depends upon the type of case. And I thought you and I could both kind of speak about different areas as to what we're going to need. In a family law setting, which is just about all that I do these days.
You need to bring in the kitchen sink, right?
Yeah, just about. Definitely the dirty dishes, or the dirty laundry. You're going to need to spend some time, if you can. Again, if there's domestic violence or something like that, you may not be able to do all these things. But if you're in a situation where you see that your marriage is on the decline, you need to take that time and start stockpiling. You need to take that time and start picking up little bits of information here and there that you can compile. So any mail that comes in, banking accounts, checking accounts, 401ks, retirement information, any of those things are going to give us a great picture of where you are financially. One of the simplest things to do is go on ahead and do a budget. Do a monthly budget and show us, look, these are my total assets, these are my total debts, this is what my income is, this is what my husband's income is, this is what my wife's income is, whatever the case may be. Certainly old tax returns are going to be helpful in that area.
Right.
And then start keeping a journal. A journal, what folks don't understand is your diary or your journal, that's admissible in court. If it's something that you're doing every day and it is getting your recollection at that moment, we can use that. We can use that to show this occurred, this is what happened, this is where I was at, this is what time it was, this is who was present, so on and so forth. Those things are very helpful. I had a case in communication with a spouse, texting, it's great. You should assume that any and everything that you text the other person is going to be read in a courtroom one day.
Right.
I had a case, I had a mom who...
And the photos will be shown.
Absolutely. And try and delete them all you want, we can get them.
Yeah, even the ones where sometimes you've got a guy that's in bed with somebody that's not his wife taking a selfie with it, and you're like, what are you thinking?
Why?
Yeah.
Why? I mean, people are morons.
Yeah.
But you and I make our living off of that sometimes.
This is true.
I had a mother, though, that she had the kid, she had her children at home. She was a stay-at-home mom, had always had the kids at home. And the father worked 60 hours a week. And when we left that courtroom, the father got custody of the kids based upon solely the text messages. Because the text messages showed that this mother consistently badmouthed this guy, just talked down about him, said that the kids are going to not love you, not respect you, I'm not going to do this, I'm not going to do that. And those text messages won that day. She was a great witness on the stand.
Yeah.
On the stand, she was bright and cheery, and yes, Your Honor, and no, Your Honor. But you get going, and no. We looked behind the mask and saw, yeah. So keep logs of that. Keep logs of your text messages. Back up your phone.
Yeah, and actually, speaking of which, we've got to cut to some PSAs. So when we return, we'll continue with talking about how to prepare for litigation. So please stay with us.
Hey, look, it's those guys. Are you good to drive?
I'm fine.
How many did you have?
I should be fine.
You should be.
You go and step out of the vehicle for me?
See ya, buddy. Good luck. So turns out, buzz driving and drunk driving, they're the same thing, and it costs around $10,000. So not worth it.
Cinderella found the pet that fits her perfectly. Tiana gave her pet the royal treatment. Belle found beauty where no one else did. And you can too. Share your heart. Share your love. Bring home your forever friend. Make a shelter pet part of your world. happily ever after begins at theshelterpetproject.org.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. I'm Vince Perryman, and you're watching Law Talk. Joining us on our show is attorney Bill Jones. We're discussing how to prepare for litigation. Bill, before the break, we were talking about text messages and just keeping backups of your phone for when you come in and you meet with a divorce attorney if you think things are going south.
Yeah.
What are some other things?
Well, I mean, I do want to urge the backup of the phone. So many times you find that folks say, oh, I've got these messages or whatever, and you can't get them because you've traded in your phone, lost your phone, whatever. So much of our life is on these things. And like you and I were talking in the break, these things are a digital tattoo. Anything that you put on your phone, man, it's not going away. Anything that you put out there on social media, it's not going away. You and I look at Facebook differently than most. That's the other thing to do. Facebook or Instagram, whatever social media is hip this week that you've got access to of your significant others, go to it. Take screenshots. Go picture by picture and take screenshots. Because once it hits the fan, you're going to be taken out of their account, and you're not going to be allowed to see their page. They'll unfriend you or whatever. It's important for you and I to be able to see it. And that's just about any litigation nowadays.
And the other thing to remember is stop using it.
Absolutely. Now, what you can't do, though, is delete or destroy. But you can deactivate. And that is so wise to do, because that's the first place I go. If you come into my office and want to talk to me about divorcing your spouse, I'm going to go look at their Facebook. And if they've already unfriended you, I can't do that. So bring me a log, and then, as you said, quit using your own.
Yeah.
Why throw fuel on the fire?
Well, and two, the other thing with that is it's not always what you post. It may be what a relative posts.
Sure.
That thinks they're helping you in some way, and then they realize that, oh, wait, no, that was a bad faux pas. And then by the time they deleted it, it's already been downloaded. And the next thing you know, you're having to address it in court.
Look, Facebook is your, or any social media, it is your original work. You are the author. Anything that you allow on there, anything that you allow to be posted on there, it is yours. And it can be used against you at some point in time. Even, man, we get into where folks have a photograph taken and they love it. They think there's nothing at it. And we look in the background and we're like, oh, you can see in the background you were driving when you took this selfie of you and your kids, and this one doesn't have the seatbelt on and it looks like it's rush hour traffic, and why are you texting and driving? So, I mean, just get off of it. Just stop it. Stop it during any type of litigation.
Yeah, and then the other thing too, I think it applies in divorces, but it also applies where you got a good co-parenting relationship with somebody that you guys aren't under the same roof with, and there's no litigation going on. Keeping a calendar of when your kid's with you and when your kid's with the other parent is important. Anything you spend for your child, if you're not on a child support order or anything like that, take that receipt, put it in an envelope.
Well, let's make sure that the viewers understand. So we live in the South, still in the Bible Belt, and with that, there are perks to being in a married relationship. So in a married relationship, you're going to go to circuit or chancery court, and your case is going to be heard there. You're going to have a formal parenting plan. You're going to go through a mediation process. There's going to be formal discovery. The rules of evidence and discovery will apply, so you and I can take depositions and go question the boyfriend or the boss or whoever. If you have not been married, if you have a child out of wedlock with your significant other, then I don't want to say you're going to be stuck, but you're going to get sent to juvenile court. They have jurisdiction over the matters where there's a child born out of wedlock.
And also, you got to remember on that 4D docket, which is under the Social Security Act, anybody can request 4D aid to collect child support.
So don't speak Greek. So what's 4D? Tell them what 4D is.
4D is just where you've got a state attorney in there
Right.
pushing the ball along, and you got the two parties. Now, the thing that you'll see, there are some practitioners that are sort of on the lower income of it. They're divorce practitioners. If the parties separate, they'll go file in juvenile court for the child support first, and then file in circuit for the divorce. And now you're having a fight on two fronts.
In two different battlefields. And that's ridiculous in my opinion, but it's what our legislators have done right now. Hopefully they'll change it if you're listening out there.
That's right.
But so you're stuck in juvenile. You're sent to juvenile court if you're unwed. This creates a unique dilemma because in a marriage situation, when a man and woman are married and they've got a child, both parties have equal rights to that child. I mean, that is their child equally. They can both do whatever. When a child is born out of wedlock, it's a different ball game.
Right.
The mother is the king. I mean, she's the queen bee. What she says is law until paternity is established. So let's look at a typical situation. A typical situation is we have a child out of wedlock and everything's fine. We're living together, things are going good, and then one day I look at your cell phone and see that you're two-timing on me or whatever, and it just goes bad. We all of a sudden go to separate households. I say, all right, when do I get to see the kid? The mom can say, never.
Right.
And I'm stuck. There's literally nothing I can do at that point. Whereas in a marriage situation, if that were occurred, there's nothing stopping me from getting my child and spending or having time with them. So the process is you're going to have to go have a paternity test. You're going to have to show that you are in fact the father of the child, and then you're hypothetically put on level ground. Sometime in application it doesn't go that way for guys, but hypothetically you are.
Well, and you're going to have to file a petition for either custody or visitation, and then get that, and that's a separate court system as opposed to the child support. And we've got to take a break again. So when we come back, we'll talk more about litigation with Bill Jones.
Right, mi cariño. So like I said, everything I learned about cooking, I learned from Grandma's empanadas. Shall we go again?
Yep.
Mix beef with the onions with the peppers with the paprika with the garlic with the oregano with the cumin. Got it?
Got it.
Throw in the olives, stir, season, stir again, pour out the flour, roll out the dough, make a circle, drop in a fistful of filling, fold over, press down, and ta-da!
Most parenting is hard to do in just 2 minutes. But 2 minutes twice a day making sure they brush is easier, and it could help save them from a lifetime of tooth pain.
So they say it's a man's world? I don't see anybody's name on it.
While they were doing their thing, we slowly changed ours.
Today, women can do anything men can do. And there's one thing we're even better at.
You are watching Germantown Municipal Television, your source for everything Germantown.
Welcome back. With us now is attorney Bill Jones. We're talking about how to prepare for litigation. Bill, before the break, we were talking about juvenile court and kind of what happens with the unmarried couples and how to prepare.
Yeah. So the whole point was we wanted to explain the system first. Now we need to take you back and tell you how to prepare for it. So when that occurs, we're going to look at how do we set up child support for this child. And the biggest mistake that I see litigants make in juvenile court is when the judge says, how much have you paid? What have you bought for them? How much are you paying monthly? When did y'all separate? So on and so forth. And if I've seen it once, I've seen it a million times. The guy stands up and he says, I take care of my kids. I give them whatever they want. Well, that's not a number.
Right.
A judge can't put a value on I take care of my kids. No one's saying that you don't, but that's not a dollar figure. And the way that child support works, we need a dollar figure, not a platitude. So in order to have that dollar figure, the second that a separation occurs, you need to start keeping a log, keeping an inventory, keep a receipt. What did you buy? Did you buy Pampers? Did you buy baby formula? Did you
Childcare.
Yeah. Did you pay for a babysitter for the day? Did you take the child to the doctor and pay a copay?
Is the child on your insurance?
Here's what you don't do. What you don't do is if mom comes to you and says, my lights are getting turned out, you do not call MLG&W and pay MLG&W, because that's not child support. That's a gift to the mother. If you want to do that, great, do that. But don't come to court and say, I want credit for paying her rent this month or credit for paying whatever this month. In order for it to constitute child support, you're going to have to give a copy or give the money directly to the mother and get a receipt for it and show that it was child support. I cannot stress enough how important a receipt is, or a canceled check is.
And if you're going to rely on the canceled check, I say make sure you put child support in the memo line and then over the back of the endorsement that says for child support, because then it's formulating a contract that it was accepted for that. It's what we use with the IRS.
It's imperative, because if not, I've seen so many guys who get down in juvenile court in a situation where they weren't married, they separated, they had an okay visitation plan, so both parties were kind of okay. 7 years go by, then, the mother hates the new guy or the new girl, and then we've got a petition. We're in court, and when that happens, it's no. This money he gave me was, I don't remember getting it. I don't remember getting it. And then this father is going to get hit with 7 years of arrearages and child support, plus interest.
Right.
And ongoing. Prepare.
And potentially attorney's fees on that.
Anytime that you're trying to protect the best interest of a child and going to court on that behalf, you're entitled to recover attorney fees. So many times these guys just get hit and beat up, and what they need to do is start keeping records. They need to keep a calendar. They need to keep receipts. They need to keep track of everything as much as they can. So let me ask you, in a contract scenario, what do I need to bring in? I want to do I'm in trouble with the IRS.
Well, if it's financial or it's a contract, you think about all of the different things that might show what was negotiated with it. So in a contract situation, if you've got an actual signed contract, that's one thing. The other thing with it, if it's sort of a verbal contract, if you have emails or text messages going back sort of in the negotiation process, that can help us figure out what it is. Checks or any payments made, that could have a signature on it, an endorsement that could treat it like cobbling back together a contract. The other thing is with the IRS, if they're doing collections against you or anyone doing collections against you, we need to have your monthly budget. What you spend, where your money goes, how much money you got coming in, and you should always prepare it 3 to 6 months back. And that's the same thing too if you're looking at going and talking to somebody about debt collection or a bankruptcy. It's bringing in all those financial documents, those prior tax returns, things like that. Same thing with a tax debt. A prior tax return can give me a really good idea if you missed some deductions, if something crazy went on, things like that. Also helps to figure out the statute of limitations, knowing when you filed, who filed it, that sort of thing.
So what I'm hearing is that just about in any type of litigation or case, whether it's from my world, your world, or whoever's, a budget is going to be very helpful to an attorney.
Yeah, and all those financial documents are always useful from the standpoint of they tell a mathematical story that's not going to be understood unless it's been processed in the right way. You know, and that's the thing with it. You know, it's one of these two. A lot of times you're in litigation, it's a he said, she said, or a he said type thing. And the whole thing there is what might you have that proves it or not? You know, if a couple's arguing about whether or not they went to a counselor and one is standing on the stand going, the other party never would agree to go to this counselor. They're an awful, awful person. And then that party then says, well, if they never agreed to go to the counselor, did you guys not go on November 20th, such and such? And then show them the Discover card bill where the counselor was paid by the other party. You know, it's one of those that these are things that you have to think, what might I have out there that is going to back up
what
my
you have
narrative?
to say. That's right.
You know, and that's the hardest thing, to sort of stop and calmly think about that.
I experience it in my practice that a lot of times when folks bring in these budget, because if they come in to hire me, that's one of the first things I'm going to give them, if they don't already bring it in, is a budget to prepare. I somehow failed to make the distinction to them. I want your actual budget, not what you're telling the IRS.
Right, and that's the thing in the last minute we've got here is it's be honest with the attorney about the reality. We know what the law is. So, for example, with the IRS, they have the actual expense that you have and they have the maximum allowable. If you're below the maximum allowable, then I'm allowed to take the maximum allowable and we don't have to show proof of that number. Now, if our number's higher than the maximum allowable, I got to show them a whole lot of proof. But you've got to trust the attorney you work with to know how to take the data you bring in and present it in the light most favorable to you.
Yeah.
You know, and that's really the whole attorney-client relationship. You've got to have that trust going both ways.
Because you don't want to. Yeah, we don't want to get caught with our pants down in court.
Yeah.
We would much rather know what we're walking into, because we can spend just about anything, but we got to know about it first.
Exactly right. And our time is up for this edition of Law Talk. I'd like to thank our guest for taking time out of his busy schedule and being with us and sharing his thoughts and insights. If you'd like more information about Law Talk or any other program on Germantown Municipal Television, please refer to our website at www.gmtvonline.org. Thank you for joining us today, and be sure to join us next season for more legal topics. Until then, I am Vince Perryman, and thank you for watching.